and they try treason, they try all sorts of things. But when the LC courts act, the law that placed the LC court, because they knew that the LCs were not trained in the law, they were not given jurisdiction over criminal matters. Not even theft of chicken, by the way. They were not given jurisdiction. So the first one is legal training. Two, the judge advocate's role is entirely advisory, as he or she does not form part of the court that deliberates on the verdict and sentence. So the judge advocate acts like an assessor whose view does not bind anyone. Three, decisions are by majority opinion of members of the court. The courts are convened and the members are appointed by the High Command or some other authority delegated by the High Command. They are not appointed by an independent institution. The commanding officer of the brigade probably would appoint who sits in the divisional court martial. The courts comprise military men with no differentiation as to whether they are active, about to retire, or have retired. Junior members and a political commissar form part of the quorum. The major and the Republican sit in the body that guides you. No right of appeal is created to the ordinary courts under the Act. The appeal ends with the court-martial appeal court. The unit disciplinary committees and the summary trials authorities exercise judicial power under the law as they have jurisdiction to pass custodial sentences and thus infringing on the liberty guaranteed under Article 23 of the Constitution. With the benefit of various authorities and instruments enunciating the law on the issue of independence and impartiality of courts martial, I have examined the structure and procedure of the courts martial in Uganda to assess how they fare in this regard. I have found as follows: legal qualification. Currently, the General Court Martial, Divisional Court Martial, and even the UDCs and STS as tribunals exercising judicial power have no legally qualified personnel on their quorum. Yet their jurisdiction is not limited only to disciplinary breaches, but extends to crimes or offenses that are also triable by the civil courts. This includes serious offenses that attract custodial sentence of over 6 months and the death penalty as well. These untrained persons can issue decisions on questions of law and fact. Go back to the example I gave. You take me to the theater in Monaco, and we don't know the difference between a kidney and the liver. And I'm fairly educated, as you know. Or put me as a brigade commander. Everybody will flee to the area and no The decision of the judge advocate in the court, who in any case is not a full member of the court, is merely advisory, as I've said, as it is not binding on the panel. The absence of legally trained personnel in the exercise of judicial power in the General Court Martial and the other military courts or tribunals is at variance with the situation obtaining in the civil courts. This presents two parallel and contrasting standards in the administration of justice. The civil courts are competent as they meet the standards laid down in the Constitution. While the courts martial function in sharp converse there, and this is inimical to the right to a fair hearing before an independent and impartial court. Hence, it adversely discriminates against persons who appear before the courts martial. The consequence of this is that it renders the functioning of the court martials unconstitutional. The composition of the court by military personnel. This issue gives rise to two distinct questions. First, whether a parallel system of military courts or tribunals staffed by members of the military who are aware of and sensitive to military concerns by its very nature, inconsistent with Articles 28(1) of the Constitution. Second, if the answer to the first question is in the positive, whether that is the end of the matter. However, if it is in the negative, then the next question is whether the General Court Martial, as constituted at the time the respondent was chaired under the UPDF Act and regulations made thereunder, is an independent court for the purpose of Article 28(1). I find that the presence of military personnel as members of the courts martial is not by itself evidence of the court's lack of independence and impartiality. However, when viewed by an objective, reasonable person, there is a difference between active servicemen and the chain of command and former servicemen who are in retirement or about to retire and are therefore not influenced by any hope for promotions. Active servicemen are under the chain of command and may be influenced through the chain of command. Furthermore, the oath taken by the members of a military court and the Rule 27 of the UPDF Rules of Procedure Regulations binds them to the High Command and Convener of the military courts. This stands in stark contrast with the judicial oath in the Oaths Act, Chapter 19. This, taken together with the non-inclusion of a legally qualified judge on the panel to rule on legal issues, denies the courts martial the independence and impartiality which would have clothed them with competence. The other judicial oath, you swear to protect the Constitution. In the military, you swear to protect the commander-in-chief, the other officers. That's the difference. That's the difference which comes out. Well, that's the law that Parliament passed in it. C, manner of appointment of its members. There is the military personnel sitting on a tribunal that handles purely disciplinary matters and only imposes such punishment as reprimand, demotion, dismissal, compensation on the one hand, and military personnel